We're good over here?
Yes.
Okay. Welcome back to the Utah Court of Appeals. Preliminaries again. I'm Judge Ryan Tenney. I'm chairing today's panel. I'm pleased to be joined by Judges Luthi and Mortensen. The second case set for argument today, and the second of four cases that we'll be deliberating on today, is in re adoption of RP and SP. If counsel could go ahead and enter your appearances, we'll start there.
Good morning, Your Honor. Sarah Frommer of the Appellate Group on behalf of Grandmother One, and with me in court is Emily Adams and Anna Grigsby.
Welcome to all of you.
Good morning, Your Honor. Hiram Bosserman on behalf of the appellees in this case. They're also present in the courtroom. Thanks.
Okay. Welcome, Mr. Bosserman, right?
That's right.
Okay. I think you're both veterans. You're all veterans of our court, but just to set the ground rules, make sure we're on the same page. We allot 15 minutes per side per argument. Looks, Ms. Frommer, like you've reserved 3 minutes for rebuttal. Do we have that right?
Correct.
There's a clock on the podium. It will work backwards. If we are still asking you questions when the time has expired, feel free to answer our questions. Don't feel like you need to ask permission. But if there are no questions and if the time has expired, it's probably time to wrap up. Are there any questions before we begin? Okay. With that, we'll hear from Ms. Frommer.
Good morning, Your Honors. Again, Sarah Frommer on behalf of Grandmother One. The caption in this case says that it's Grandmother One versus Grandmother Two. But this isn't really a dispute between the two grandmothers. This is a dispute between the best interests of the children and the technical interpretation of the intervention provision of the Adoption Act that informs the order of the lower court that is on appeal here.
I don't usually jump in this early, but I want to this time and just make sure that I understand which arguments you'll be pursuing and which ones you won't. Because by the time I got through reading the reply brief, it seemed like things had been narrowed in more closely than in the initial brief. Are you making a as-applied constitutional challenge to the statute?
No, we're not making an as-applied constitutional challenge. We're making a statutory interpretation challenge that says that to interpret this intervention statute in the way the lower court interpreted it does violence to the purpose of the Adoption Act, one of the overarching purposes of the Adoption Act.
Let me just follow up with two quick questions, and then I want to hear about that. We all do.
Yeah, I'm sorry, Your Honor, I'm having a little bit of difficulty.
I'm sorry, I'll
hearing you.
speak up. You're not asking us to reverse the court's decision unconsolidating the case, are you?
No, because it's pretty clear that under both Rule 42 and other case law that the court can decide whether to consolidate these cases or not. Indeed, even in the Supreme Court in RCC said that they don't have to be consolidated. They can be deconsolidated. They can be unconsolidated.
This is my last question then. It appears that you're also conceding that the plain language of the statute is not in your favor, and that this case really hinges on your absurd results argument. Is that correct?
It does hinge on that, but it also hinges on the argument that the intervention provision, I have always thought of the intervention provisions 78B-6-1106. I've always called it I've always thought of it as the anti-straggler provision. That it's basically saying, look, you know, there's an adoption petition pending, there's an issue of these children, of the best interest of the children, and if you want to participate in this process, you better show up. And you better show up, and you better prove that you're a legitimate person to show up, and you better do it in a timely fashion.
I take the point, just cutting to the chase on this one, I take the point that you've made, and I take the purpose argument that you've advanced in the brief. And the response from the other side is, if you just look at the plain language, what we have is 6A says the party, quote, shall file a motion to intervene. And we've got all this case law that seizes on the word shall and says that it's a term that the legislature uses advisedly, and it imposes a mandatory condition. And then you get to 6B, and the language says that a person who fails to fully and strictly comply loses their rights. And so if one were constructing a law school hypothetical in a sort of statutory interpretation scenario, and you're trying to say, hey, what would it look like when the legislature really, really means something? I don't know how else you'd write it other than you shall do the following, and if you don't strictly comply, you'll lose your rights. Why is that wrong?
Well, and
That's your hurdle.
my response to that would be as follows. The statute requires strict compliance with notification and with a time period. And as I said, under my anti-stragglers characterization of this provision, if there is only one adoption petition, there is only one way to play in that game. You're not a party and you can't play in that game unless you file a motion to intervene. And so I would argue that there's no clearer interpretation and no clearer indication of the fact that they were talking about when there is one petition pending, you must file a motion to intervene and it must contain these information and you must do it in a timely fashion, which is consistent with the legislative intent that adoption, that placement of the children should be done promptly and that parties should not be permitted to interfere with an adoption placement later on. In other words, the no stragglers.
But if the legislature had wanted to say that, it could have said that, but the phrase that you run into, I think, is the phrase from 6A where it says the party, quote, shall file a motion to intervene. So the legislature doesn't say a party fails to provide a notice of its objection or a notice of its intent to adopt. It could have said a lot of different things than shall file a motion to intervene.
Well, but then you have to look at what is the purpose of a motion to intervene. The purpose of a motion to intervene is to allow the party to play in the game.
But as a matter of ordinary statutory interpretation, we only get to purpose if there's an ambiguity in the statute. What's ambiguous about that?
Well, because there is also a provision, as the appellees pointed out in their reply brief, after well, first of all, you have CC. In re CC is a case of the Utah Supreme Court that said at the time that case came down, there was no provision in the statute that addressed the situation where there were competing petitions. And if there are competing petitions, in re CC says, the best interests of the children must be held paramount, and the best interests of the children require that both petitions be heard. And now the other side has raised the issue of, well.
So I don't know if I'm characterizing your argument correctly, but so tell me if I'm not. Is your position that even as a matter of statutory interpretation, that the best interests overlay allows us to sort of create an ambiguity within that statute, or to just sort of disregard the plain language? Or?
Well, the rule of statutory construction in 68, I never remember, 68-3-12 sub 1, says that the statute should be strictly construed unless the construction is inconsistent with the manifest intent of the legislature or repugnant to the context of the statute. Strict interpretation of this statute, which requires, to the extent that it requires a procedural maneuver, motion to intervene, is repugnant, and if you have failed to apply that procedural mechanism, you are now out of the game. And we're talking about two small children who lost their parents and who have been cared for by two grandmothers this entire time. This ruling says that one of those two grandmothers is out of the game. That is not in the best interest of the children, and indeed nowhere in the order from the district court do the words best interest of the children ever appear.
We have a bunch of cases where, for example, biological fathers make appearances in cases late, and our courts have been quite consistent saying, no, you haven't met the requirements of the statute, you're out. And in none of those cases that I'm aware of, is there a best interest analysis saying, we're going to go look at the best interest of the child first and then determine whether we still want to apply the statute. And they could be even described as harsh and heartless. They say, no, if you've missed these deadlines to establish paternity or whatever, you're just out of luck.
Yeah.
Why didn't those cases wrestle with this best interest analysis that you're talking about?
Because they were late. Under my no stragglers rule, if you are late, if you have not made your interest known, and you have not identified that you are someone with a legitimate interest to participate late, then you are out of luck. And that's consistent, again, with the overarching legislative purpose of 78B-6-102 5 that says the legislature has an interest in the prompt placement and the avoidance of later attacks of adoptive placements. So if you are late, if the thing that has been violated, if the thing that has not been strictly complied with is the time frame, then you are out of luck. And that's what all of those cases stand for. Now, back to what I was
And
saying
the-
before.
even if, just to be clear, even if the evidence were that it was undisputable, just clear as day on the record, that it was in the best interest of the child to have this late appearing person in their life, if they're late, we don't care.
That's what the cases all say, if they're late. But grandmother one was not late. She's grandmother one because she filed first.
Let me ask you this question about CC. You've put a lot of stock into this case, and I want to make sure that I'm understanding your argument. It seems to me that what the court is saying in Re CC is, if there are competing petitions for adoption, you have to have a hearing on best interests. But in our posture of this case, there hasn't been a finalization of an adoption, right?
Not yet.
Right. So if we were to affirm, there wouldn't be competing petitions for adoption. Is that also correct?
No, there were always competing petitions for adoption. If you affirm, you're just saying one of them can't go forward.
Okay, I'm just trying to understand how In Re CC actually informs this issue that we're on at this procedural stage of the case. It seems to me that In Re CC was talking about a different procedural stage.
It was talking about the procedural stage that existed in the district court, where there were competing petitions. And in Re CC, the juvenile court had actually already approved one of the adoptions. The child was adopted. And In Re CC overturned that adoption order and said, no, the competing adoption needed to have been heard as well. Because whenever the child's best interests are addressed in two competing petitions, the best interest of the child requires that both be heard. And that's, the CC is quite clear on that. Now, as the appellees pointed out, that there is a provision in the Adoption Act that does address the issue of in competing petitions. It was added after In Re CC. In Re CC was 2013, and the provisions 78B-6-133, 7, 8, and 9 were added in 2015. And what 78B-6-133 sub 8 says, that if there are two competing petitions, the court shall grant a hearing on a petition that was filed by a custodian or a guardian. And here we have two of them. And so not only do you have to reconcile the interpretation of the intervention statute, the intervention provision of 78B-110-6 is that, or -6-110, with the overarching purpose of the Adoption Act, which is the best interest of the children are most important. You also have to reconcile it with the provision of the later added provision of the Adoption Act that says if you have two competing petitions, it says basically exactly what the Supreme Court said in Re CC. If you have two petitions and both of them were brought by legitimate people, you have to have a hearing on both of them. And it stands to reason. Oh, I'm out of time. That went
You're out of
fast.
time, but I wanted to ask you a big picture question before you sat down, unless you have more.
I have a follow-up question from the questions that I asked kind of at the outset. My last one was about absurd results. The you use the term hyper-technical reading throughout. It seems like, though, to say that the reading, that is the technical or hyper-technical reading is, well, that's where the plain language takes us, is in favor of the other side. But your most compelling argument to me seemed to be, even if that's where the plain language takes us, the plain language takes us to an absurd result that was not contemplated by the legislature. And CC does seem to be helpful to you in that regard, because the Supreme Court said there that the statute is silent on the issue of competing petitions. That's a quote, which seems to suggest that our Supreme Court has already said, yeah, the legislature didn't think about this, and which could lead us right to analyzing, is this an absurd result, or is this one that the legislature could have reasonably been thinking about?
Well,
Will you just address that briefly?
The legislature, again, as I said earlier, when you're talking about a motion to intervene, why do they require a motion to intervene? What is the purpose of a motion to intervene? It is to give a party status in a proceeding in which they do not otherwise have a role. And when you only have one petition, that's your only choice. And so if you haven't done that in a timely fashion, then you have blown the requirements of the statute and you're out of luck. Where the competing petitions come in is you now have another mechanism for satisfying the concerns. And the Supreme Court also said in KTB, which is not exactly on point in this case, and we grant that. But what the Supreme Court does say in KTB is the purpose of the intervention statute. The purpose of the intervention statute is to notify the court and the other parties as to the intent to participate, and to establish the bona fides of the person who's raising those issues. That is, according to the Utah Supreme Court in INRI KTB, the purpose of the intervention statute. It's not to satisfy some hidebound procedural requirement that it must be done by a piece of paper that says motion to intervene on it.
Before you sit down, one of the things that I'm just still left wondering off of the briefing, and you've kind of hinted at your answer in the briefs, but I just want to ask it. Why didn't your clients file a motion to intervene? I can't wrap my brain around why they didn't do that. What was the reason for not doing so?
I have no idea.
Okay, so I'm not alone on
suspect, but what they said, I mean, I don't know. I know what they said is that they thought, everybody agreed in this case, and this is where the consolidation pleadings come into play. Everybody agreed that these two adoption petitions involve exactly the same issues, exactly the same facts, exactly the same parties. And I suspect, if I had to suspect, that they didn't think they needed to because they already had staked out their position.
Right. I mean, you said that in the briefs, and that resonates with me on sort of an intuitive common sense level. The response in the red brief to that was, right, but they were then told, 2 times, 3 times in various filings, the notice was given that if you don't file a motion to intervene, this is what will happen. And it's just a little jarring to me. I mean, we will answer the question. This isn't going to be a mechanism for us not answering the question, but it baffles me a little bit that we're even here where there was such an easy thing to be done that just solves this whole problem. I can't really understand why that didn't happen.
And Your Honor, it would have solved that whole problem, of course. And if they had done it, we wouldn't be standing here now having this argument about whether it should be dispositive of this issue. But because it could have been so easily resolved, and because the motion to intervene would have just said the same things that the adoption petition already says, then the issue becomes, is it really in the best interest of the children to require that it be done on this piece of paper with this heading on it, when the purposes of the intervention statute have otherwise been satisfied?
But it's not just that, though. I mean, the one additional piece to what you just said is it's a piece of paper in this particular case as opposed to another case. I think that's the hook for that argument, is the reason the legislature wants a motion to intervene in the other case is so that you have something filed in the other case that stakes a claim, right?
Well, and that would be an issue if the people in the other case hadn't already agreed that both cases should be consolidated and they involve the same issues and identical witnesses and identical facts and so forth. And so the reason that you stake the claim in the other case is again to give those notifications. And if the result in this case were simply that they weren't allowed to participate in that case, that would be maybe awkward at the, back at the trial level. But the result in this case is that they go on and apply the other subsection of the intervention statute and say, you can't play in the adoption game at all.
Right.
Which means that these two minor children who have been at least half-time in the care of grandmother one the court doesn't get to consider whether grandmother one would be a better placement. And not only that, grandmother one doesn't even get to object to grandmother two. And that is a result that does violence to the overall purpose of the statute under 78B-6-102. It does violence to the best interest of the children, require both petitions to be heard, language of in recess.
Okay.
And when a statutory interpretation does violence to the purpose of the statute, then it should not be strictly construed.
Great. Appreciate your argument. We kept you over. You'll have your full rebuttal. We'll hear from Mr. Bosman.
Thank you, Your Honors. May it please the court. This case is about a pretty straightforward application of the intervention requirements in the Adoption Act. As we've heard, and in fact, as appellants have conceded, that the plain language of the statute gets us to where we are. If you need any further proof of that, you can look at the reply brief, page 17, where they openly admit that it is unambiguous as what is going to happen in this case. That is what the plain language says. Now, this court, there's a lot of perhaps equity arguments that can be raised here, a lot of is this fair or not fair, but what we have in front of us is a strict compliance statute.
Okay, let's just go there. What do you understand the purpose of the intervention requirement to be?
Yeah, the purpose of the intervention requirement, I would say, is threefold. First, it provides notice not only to the parties of who is going to actively participate in the case.
Okay, let's get the bullet points and then what's for them.
Yeah, absolutely.
So it gives
the first
them
is
notice.
to actively, and that's not just for the parties, but for the court to know who is going to actively participate. Second, it sets forth the grounds for competing, right? Grounds for contending the
Okay.
adoption.
And then the third would be what?
And the third would, in addition to that, would, I think it couples with it. Sorry, notice to the parties, notice to the court.
Right. So that's what you gave us on page 20 of your brief.
Yeah.
It's the same thing. Which of those two things is not conveyed by the competing adoption petition?
Well, one, for the first instance, when you have two competing adoption petitions, right, it's not unusual to suspect that one case and one court would have no knowledge of another.
But we don't have that
adoption petition.
dynamic here, though.
Sure, I understand and I appreciate that here, right?
So in this case, if the two purposes of the intervention requirement are notice to the parties in the court and notice of the grounds for contesting the adoption or for contending that the person has parental rights, which of those two things is not already accomplished by the first-in-time adoption petition?
The second, Your Honor.
In what way?
And they did not file anything in this court telling us the grounds for why they believe our clients, appellees, should not adopt the children.
But wouldn't their own adoption petition tell you everything you would want to know about what they think the grounds are for contesting your client's right to the children?
Not necessarily, Your Honor.
In what way? What's
Now,
missing? What's
it-
the gap here? 'Cause
what
I'm
the-
struggling with that.
I apologize.
No, you're totally fine.
What the notice shows, right, is that they intend to adopt the children, right? Now, is that their only ground? We intend to adopt the children, and we don't want you to adopt the children. They don't even say that. We don't even have that in this case.
I'll confess, it's been a minute since I've looked at their petition, but correct me if I'm wrong. I would assume that their own adoption petition would set forth the grounds by which they think they can adopt the children, right?
Yeah, absolutely.
So if they've set forth the grounds by which they think they can and should adopt the children, then doesn't that give the legal grounds for opposing your client's petition to adopt?
I don't believe so, because I think you actually have to show why you don't believe our clients have the right.
Isn't that inherent in the best interest analysis? That if your petition says it would be in the best interest for us to adopt them, you're inherently saying, and it would not be in the best interest of the children for the other folks to adopt them?
Perhaps.
Anyone else to
But
adopt.
perhaps, but that is why we have these things, is we don't have to say, well, is something implicit, or do we infer that that's what they mean? We have a requirement that actually tells you must list the grounds. We have to know the specific grounds in this case.
But you can't have multiple, the child gets adopted by these parents or it gets adopted by these parents. And so if grandma one, to use the nomenclature of this case, if grandma one adopts the children, then grandma two can't adopt the children, right? And so the ground for opposing grandma two's adoption petition would be, I want to adopt them. I'm coming back to the same question. I mean, you knew this question was coming, and this is the sort of centerpiece of that side of the argument, which is I can't figure out what you think your clients didn't know that they would have known with a motion to intervene. Like what's the new knowledge that they get from the motion to intervene that they don't already have?
Sure. And as I've said, we don't believe they've set forth the grounds in that. Now, I don't think that question actually ultimately matters in this case, because that isn't the standard for determining whether somebody's rights are forfeited in a child. Did they actually?
But if what you're proposing is an interpretation of this statute that doesn't add any procedural or substantive, any additional procedural or substantive knowledge, then I think what they would have us say is that can't possibly be what the legislature intends in this scenario.
Well, I think the case in Ray KTB sheds abundant light on this very issue. In that case, if you walk through that case carefully, they're considering the very same provisions that we're talking about in this case with respect to a biological mother. In that case, the Supreme Court specifically states that this provision, specifically the 30-day timeliness requirement, under a strict scrutiny test even, satisfies all the prongs, that you have to strictly and fully comply, that there are compelling reasons behind that, including, and I guess I'd give one other caveat that I should have said in terms of the reasons behind why you need to timely intervene. And I failed to mention this before. There's a third additional one that I think is quite important.
Yeah, you had said three and you didn't get there.
And I apologize.
No,
The third
totally
one,
fine.
and I should have looked at my outline here. The third is to ensure that the case moves forward promptly. And that's the most important one, right? Here we are, far, far removed from the district court's order in this case, and we still don't have an adoption because of this very reason. If you timely intervene, you are a party in the case, you can ensure that your rights are protected, and you ensure that there isn't procedural messes that stops the prompt adjudication of a child's adoption.
Here's
Can
what
I,
I
can I,
think,
can I,
Yes.
go ahead.
here's
Yes.
what I think the best response to that argument would be from the other side. And I'll say again, I think that this all comes down to, is the plain interpretation absurd or not? And I think that the Supreme Court has said, we don't think the legislature thought about competing adoptions when they set this up. And so if we say, we'll take the Supreme Court at its word, legislature didn't think about this scenario. Is this absurd or not? Your argument seems to be, would have to be, the legislature was so concerned about promptness that that it's not absurd, that we will disregard a potentially best interest fit for the children because promptness always is going to take priority. To me, that does sound a little absurd given everything that is said otherwise in statute and case law about best interests of the children, that we're going to prioritize promptness over best interest. That seems absurd.
I'll tell you why it's not absurd. Repeatedly, the Supreme Court has taken these strict laws, that's what they categorize them in the case law, these strict laws in the Adoption Act, and disregarded a biological father's rights or any other person's rights in a child without doing a best interest analysis. Now, I think it's important for the court to understand that just because the appellant's petition is not going to proceed forward, that does not mean that a best interest analysis will not be conducted in this. Under Section 137 of the Adoption Code, a best interest analysis is required before any adoption is taken. And I will note, if you go through the the structure of the Adoption Act, you'll see 128, 129, 130. There's these pre-placement evaluations. There's a home study done by a licensed professional, right? All of that is submitted to the court. There's background checks. You have to live with the potential adopting party for over 6 months. And then there is this final disposition hearing that takes place at the end of it, where the court considers and even hears from witnesses on whether this is in the best interest of the child. So what's happening is we're kind of putting the cart before the horse. At no point does the legislature say that we have this one out of, there was 3 purposes of the statute that was identified. Best interest of the children, the party's interest in the children, right, and the prompt manner of adjudicating it. At no point at any point in the Adoption Act does the legislature say, you can take the best interest purpose and use it to basically read out any other provision of this. In fact, the best interest in analysis will come later in this hearing, and that hasn't even been adjudicated here.
Can we
And what
play
I
that
will-
part out just a little bit, just because I didn't practice in adoption law, so procedurally, help me play that out. Let's say only the one petition proceeds, you have your best interest analysis, Grandma 1 comes and testifies at that, and the court says, you know what? I don't think it's in the best interest to go with Grandma 2, deny that petition, then where are we left? And could Grandma 1 then refile and proceed?
No, Your Honor.
So-
She could not, but I
so
think we
is
would be
there-
back to the guardianship arrangement that we have at this instant, perhaps, right? And so what I'm saying is, and I think it's important to note.
I don't necessarily agree with his first point on something being absurd, but that outcome to me strikes me as being completely absurd. That then it would be King's X, that neither of these, because the legal effect of what you said just now is if this petition, the surviving petition is denied, now you have 2 denying petitions, so neither of these people can adopt. I think you just said that. It'd have to just stay in perpetuity in guardianship. Is
And
that
I'm
what you're
not
saying?
conceding that, Your Honor. I'm not saying that it would stay in perpetuity. Somebody else could adopt, or perhaps at some point in the future, our clients could refile. I don't know if it would
So
be.
your clients can refile, but they can't?
I'm not positive how that would play out in the future. Now, you saw below, the only argument, and I think a lot of these things we can all avoid if we just go to the preservation grounds in the first instance that we argued
Well, before you
beforehand.
get there, I do have something I'd like
Yes.
to ask. You said that the reason a party needs to file a motion to intervene is so that they can obtain party status. Is that right?
That is, yep.
Okay. And I'm not asking, I totally understand that according to you, we're not gonna review the whole reversal of the consolidation order. But I need to talk about an alternative universe. Had the court not struck the order to consolidate, and had the case stayed consolidated, so one case, then they would have had party status, right?
That's incorrect.
Okay, tell me
And I'll
why.
point you to the case. If you look at this case called In Re TB, that's Utah Code 2010 UT 42. It was cited in the briefs. Here in this case, we had a petition to, the father petitioned to have, he had what was called a paternity action. A biological father filed that. That paternity action was consolidated into an adoption proceeding that was ongoing at the time. The Supreme Court looked at that and agreed. The mother argued, even though they're consolidated, they are not a party. Because under the strict language of the intervention laws, you cannot become a party until you intervene. That's what it says expressly in section, I believe it's 1.
Okay, well, let me tell
46.
you the reason I'm asking this, and
Uh-huh.
maybe that case is the answer to it, but in your brief, I think you said that the order striking the consolidation was filed in all 3 cases.
Correct.
So I got on my little computer and I tried to verify that and I couldn't find it. So then I went to the guardianship case and I found the order striking the order to consolidate. And it appears what happens, tell me if I got this wrong, but Judge Lamb signed at 2:40 in the afternoon on March 30th an order consolidating, and then the next day he struck it. Is that what happened?
I believe that's correct,
All right.
Your Honor.
And in his order striking the consolidation, he says, the court strikes the order granting the motion to consolidate adoption cases, gives the numbers in Duchesne County, signed by Greg M. Lamb. So Judge Lamb was very specific that the order that he was striking was Greg M. Lamb's order, which has to be the order that he signed the day before, right?
I believe that's correct.
All right, well, in the adoption cases, we have an order consolidating them from Sam Chiara. So it appears to me that the order striking the consolidation didn't strike this order of consolidation. So are the adoption cases still consolidated?
They are not, Your Honor, and they were, and in fact, they were never considered consolidated. And this is something that hasn't been challenged on appeal whatsoever. I will point
I'm
the
not-
court to,
It's not, they don't have to challenge it. I mean, the legal effect of an order is what it is. So.
I understand that.
Okay.
If you go to the ruling, specifically in the
Can
ruling.
I ask my question?
Oh, I apologize.
Do you purport that Judge Lamb's order striking the consolidation purported to strike Judge Chiara's order of consolidation?
So Judge, my understanding is Judge Chiara had a minute entry saying that they shall be consolidated. It was the venue was transferred over to the 8th District. Judge Lamb then, pursuant to that, entered an order reflecting Judge Chiara's minute entry and then
I see.
abruptly deconsolidated.
Okay.
And if the court needs record proof that these did go out, we briefed that at length, and the factual disputes over whether notice was provided in those adoption cases was never challenged. If the court needs those citations, I'm happy to provide where we have,
So I
Green
get what you're
filing
saying. You're saying that the
notifications.
order from Judge Lamb was the written order from the minute entry, even though the minute entry says the word order and is signed by Judge Chiara. Is that right?
I would say that that Judge Lamb's order was reflecting the minute entry that was given by Judge Chiara.
Okay.
That there wasn't an independent, if you're asking if there was an independent determination by Judge Lamb on motions to consolidate, I don't believe
That's
that's.
not my question, no.
But the record cite to the provisions where we have at least green filing notifications that went out to all council is, it starts, Your Honor, in 326. And you'll see that there's, in the guardianship case, and we've attached the docket, and it goes to 334 in the record. And
I just didn't see, when we pull up our docket, we have two tabs. One's our docket and one's a district court docket. I did not see a docket entry in the adoption case reflecting Judge Lamb's order.
And perhaps one of the reasons, if I may, Your Honor, that you didn't see that is once they came over to Judge Lamb, after the ordered striking consolidation, they got independent new case numbers. Perhaps you're looking in those new adoption case numbers, not the previously appointed case numbers. And if you look at the case numbers for these green filing notifications that we filed with our summary judgment motion, you'll see that they're actually showing cases that were the previous case number assigned to the adoption petition. For example, on 334, this is case number.
Did it change your case number on your petition?
Yes.
Okay.
In this case, it was case, this is the prior case, 213000078 was the appellant's adoption case. And you'll see on 334, it says copy of Judge Lamb's order striking order to consolidate. And it's a green filing notification sent to council.
Do you have more on that, or?
Nope.
Okay. You had mentioned preservation, we're at zeros, but let me just ask you a preservation question, and then maybe we can spend a minute or two, but not 5 on it. Fair?
Sure.
Okay. There's been much discussion in the briefing about preservation. You said in the red brief that they did not preserve. Reply brief, page 3, has a whole paragraph that carries over to the bottom of 3 through 4, and they've got a lot of quotes and a lot of record sites that seem to have made the argument, although they didn't cite in re CC, they're quoting stuff that happened below that seems to have made the argument that it was in the best interest of the children to have both of these petitions heard, and that that's a reason for the court to deny this motion for partial summary judgment under the sort of best interest rubric. Why doesn't that get them past the preservation hurdle, at least as to that argument?
Yeah, I think you have to go back and look at what the context with those comments were actually made. If you go to the hearing, and in fact, in the brief, we'll talk about the opposition filed by the appellants below, they first off conceded that the court could do what, on page 246, they straight up concede that you should actually dismiss her claim, but you can't do it with prejudice. It has to be without prejudice. And then the rest, all of these comments are made in the context of what is going to happen is kind of these hypotheticals we're talking in the future. If her claims are barred in this case, and I would note that before, to the extent anybody's arguing that she's barred in the other case, the appellee's case, that is not what Judge Lamb ruled here. He specifically said in his ruling, this case, you are barred from maintaining your claims or participating in this adoption proceeding, is the exact quote. Anyways, what they were suggesting there was what is going to happen in the future. And opposing counsel there said, well, at some point in the future, we should still be able to participate in any sort of combined evidentiary hearing or something that we can come in and talk about the best interest of the children. What I'm talking about under section 137, the final disposition hearing, that we can participate in.
But I'm just reading the quotes that they've given us. I'll go back and read them in context. But in the middle of that paragraph at the bottom of page 3 of what's really the bulk of page 3 of the reply brief, I don't know how to point you to the place I'm looking at. Midway through on the right, she says she argued generally that, quote, her exclusion from the adoption proceedings would, quote, strip the district court of the ability to adequately adjudicate the best interest of the children in the adoption matter. That sounds to me like she's saying that she can't be excluded from the adoption proceedings because it would strip the district court of the ability to adequately adjudicate the best interest. Why? That feels like the argument that I'm hearing in their brief.
And what I'm saying is the distinction there is they're talking about excluding her from participating in the best interest hearing later on, not talking about excluding, not talking about that there is some prerequisite best interest analysis that must be conducted right now before you can.
Right, but the only reason that you would strip her ability to participate in the adoption petition of grandmother 2 is the failure to file a motion to intervene in that petition, right? I mean, that's how you get to that place. And so if she's saying you shouldn't do that, then we're back to the argument they've given us in the blue brief.
And I think it's a wholly distinct issue. I'd point the court, and I know the other side never cited to it, but we pointed a million times in our brief to the case called Amigo LLC versus Synergy Company. It's the Utah Supreme Court's most recent iteration on preservation. There, the Supreme Court said, quote, this is paragraph 18, quote, we view issues narrowly. Amigo's effort to evade our preservation rule by broadly defining the issue it raised in the district court is unavailing.
Is that true in the child welfare context, though, where we have this broad overlay of best interest analysis?
Yes, absolutely. In fact,
Is that case dealing with statutory interpretation?
this case is not dealing with statutory interpretation.
Because to me, it seems like once you raise interpretation of a statute, it's incumbent upon this court to get the interpretation right.
Yeah.
And that we ought to broadly construe the idea of issues so that we don't say, woo, well, if they'd only have said this, we'd say the statute means this, but since this party didn't make the right argument, we're going to give you the wrong interpretation of the statute. It seems like we've got to be very broad.
And I would argue that the statutory interpretation was never really an issue that was raised by their side. Again, I say they conceded it. They never really provided the court with any sort of other meaning that it could possibly be down below.
Did they make the absurd results argument?
They did not. They never made, and that's another point I wanted to raise. Never before did they say absurdity. And in fact, in their opening brief, they don't mention it once. There's nothing in their opening brief that talks about absurdity. And under the well-known case law in this court, they've waived that issue as well.
I guess that's where I wrestle a little bit with the idea that now that it's been raised in a reply brief, if the court says, we think this is the right interpretation of statute as a matter of law, but we're going to give the state the wrong interpretation because this individual litigant didn't make the right argument at the right time.
Yeah.
That seems problematic.
I think that happens all the time in terms of weighing, did we have a fair and just opportunity to come back and talk even about the absurdity doctrine? We didn't. All of the authorities are in the reply brief. They were never raised down below in any way or form. They didn't argue for an absurd result. Last point on the absurdity doctrine, I think it's important to look at case in re BH when you're looking at the absurdity doctrine. There, the court talks about that the result has to be so overwhelmingly absurd, right? And to get to that, they actually go through in that case and say, we're gonna look at the plain language of the statute first to determine whether the court actually intended this consequence, right? And here, it's clear, there is, as we've detailed in our brief, there is no other interpretation. There's no other way you could suggest that the legislature didn't intend for this to happen in competing adoption petitions. They said, you're barred thereafter from bringing or maintaining an action with interest in the child. And if you want further proof of that, in re KTB, all the other cases talk about that this fulfills the prompt manner intent of the legislature.
Great. Thank you very much for your argument. Appreciate it. Unless there are any pending questions, which I don't see, we'll hear the rebuttal. Thank you, Mr. Bossman.
Thank you. Apologize.
Can I hijack your reply or your rebuttal just a little bit and have you respond to two things that just came out? Is it true that you conceded below, that you conceded this below, that it should be dismissed?
I'm sorry, can you say that again? I have a hearing issue. so-
No, yeah, and
It's not that I'm not listening.
yeah, no, it might be me as well. He just told us that on page 246 of the record, you conceded, your clients conceded below, or your predecessor counsel conceded below, that the court could or even should dismiss your client's petition. Is that right or is that wrong?
No, I think we were saying if it did,
Okay, so you're saying there's an if there.
if it did.
Okay. The
If
second,
it did, then these results would follow.
okay, the second thing I wanted to ask, and I suspect I'm beating Judge Luthi to the punch on this one, is it true that you never argued absurdity below? And if so, how did we get there ourselves?
Well, we did argue below that to interpret the statute in this way does violence to the intended purpose of the best interests. The best interests are most important and so forth. And so although we didn't specifically say that this interpretation is absurd, we did put all the pieces into place. And as Judge Luthi points out, and as in fact as the Utah Supreme Court has pointed out, that when there is an issue of statutory interpretation, it is incumbent upon the court to get it right. And it is incumbent upon the court to say, is this the result? And what the absurdity doctrine means is it doesn't literally mean, oh, this is absurd. What it means is that, as the Utah Supreme Court has defined in Bagley, which addresses the issue very thoroughly in paragraphs 26 through 29, it says that the absurdity doctrine applies. It follows if the legislature could not reasonably have intended the result. And so you have to ask the question, could the legislature have reasonably intended that the result of failing to intervene when you already have your own petition on file would be that you would be knocked out of the game? And we don't have to speculate on the legislative intent, because after CC, they added 78B-6-133-8 that says if there are two petitions, both get a hearing.
So,
And it
but
doesn't say-
if we can conceive of a reasonable reason the legislature might do that. For example, let's say somebody files a petition for adoption in Logan and the other grandma files a petition for adoption in Washington County in St. George. It might make sense to require them to intervene in each other's petitions, so that maybe somebody can file a motion to consolidate, or at least tell each court, look, there's other people that are interested in pursuing this.
Yeah,
Wouldn't
and
that be a reasonable thing for the legislature to do?
if those were the facts, which they're not, and in fact, the facts in this case are sort of those facts. They were filed in the same court, they were in front of the same judge, there was a motion to consolidate, everybody conceded they
What I'm
involved the
getting
same
to is
interests.
the legislature may not have anticipated your facts, but could they have been anticipating competing petitions potentially being out there and saying, yeah, even in that case, we'd want people to file motions to intervene to make sure that they're keeping all of their, all these courts apprised of their interests.
So are there circumstances under which motion to intervene perhaps should be required? Is a different question than does this statute require a motion to intervene no matter what the other facts are? And to interpret it in that particular way is our contention does violence to the intent and purpose of the Adoption Act. And again, we don't have to speculate as to what the legislature intended. The legislature cleaned up the problem after CC by saying, we agree with CC. If there are two petitions and the parties are of proper standing, then they both should participate. If I could just add one other thing, because I see my rebuttal time is out.
It is. Be
The
brief,
one other
but
thing I
move
wanted
along.
to say is that Counsel for Grandmother 2 argued that Counsel for Grandmother 1 didn't advise, that her petition doesn't advise of the grounds why she would be a better choice and Grandmother 2 would not. But that's not accurate, because if you look at the record and the petition, and Grandmother 1's petition, she says that they should pick her and not Grandmother 2 because the kids are more bonded with Grandmother 1 than with Grandmother 2, that Grandmother 2 has been more of a grandparent than a parent, that Grandmother 2 has threatened to disinherit the children, that the children prefer to remain with Grandmother 1. All of those allegations are contained in Grandmother 1's adoption petition. So in response to your question, what would they know through a motion to intervene that they don't already know from the filing of the adoption petition? The answer to that is nothing. Thank you, Your Honor.
Thank you.
And thank you for your time.
Yeah, no, always. We appreciate the arguments presented both in the briefs and the arguments. We're great on all fronts. We understand the sensitive nature of this case. We'll do our very best to issue an opinion as soon as we can while still doing the work that we've been tasked with doing. And with that, we will be adjourned for today. Thank you.